Hi everyone, and thank you for joining us today. My name is Tina. I'm the Capability Building Coordinator for Connecting Up and TechSoup New Zealand. Connecting Up is a part of the Info Exchange Group. Info Exchange is a not-for-profit social enterprise that has delivered technology for social justice for over 25 years. With over 100 staff across Australia and New Zealand, we tackle the biggest social challenges through the smart and creative use of technology. I'd like to welcome you all to the webinar Privacy in Australia and New Zealand for Not-for-Profits, which will be presented by Jody Siganto and Thomas Mackey. We'll start with a little bit of housekeeping. All lines are muted, so if you have any technical issues, please type it into the questions box on your webinar panel, and I'll be able to assist you through there. If you have any questions during the session, please also type it into the questions box, and Jody and Tom will answer them in the Q&A section at the end of the webinar. Please note that your comments and questions will not appear to the entire group. If you are on a Wi-Fi connection and have multiple programs open, this can sometimes affect the quality of your audio and video of the webinar. If possible, please close all other programs to help you have the best experience. Please note that the webinar is being recorded, and a link to the recording and the slides will be sent to you shortly after the webinar ends. Before we start, I'd also like to remind you that there will be a short survey at the end of the webinar. We'd appreciate it if you took a few minutes to provide us with some feedback. That's all from me for now. I'll hand it over to Jody and Tom to get things started. Thanks.
Oh, great. Thanks a lot, Tina, and welcome everybody. Today we're going to talk about some privacy issues in Australia and New Zealand for not-for-profits. It's a fairly big topic that we've got, and many things that we could cover. We've tried to pull out some areas that we think will be of specific interest to people who are operating in the not-for-profit area, as well as some of the kind of more general things to be aware of. So, all right. Let's just make sure this is working. So this is what we're going to talk about, what kind of organisations are covered by the different privacy laws, delving a little bit into what is personal information, because that's the thing that's regulated, talk a little bit about what you need to have in your privacy notice or policy, and then some other important issues around the way that you collect information, how you procure consent, and then something that I suspect is at top of mind for lots of people, which is marketing. How do you get out to the people that you want to connect with, whether it's your clients or with potential donors or other partners, under both privacy laws and spam laws. So both privacy law and spam law have got some application in this area, and we'll kind of talk about both because sometimes I think it gets a little confusing. And then just a little bit on cloud service providers, and finally a bit on data breach notification obligations. So again, I think hitting on some of the kind of the most topical and possibly the areas that often cause lots of issues. So this is me. I am a lawyer by background, but I've been working in the privacy and information security space for nearly 20 years now. I do a lot of consulting as well, do a lot of training, as I said, particularly in privacy and information security, and in that sort of that spot where privacy, security and the law all come together. So talking about privacy laws in our area of the world is something that is kind of been my bread and butter for many years. As well, we've got some of the things that we can do there to help organisations who need assistance. So just first off, to give a little bit of context, there seem to be a lot of misconceptions around about privacy, and I think this is getting better, but it seems that I have the same conversations often about some of these kind of fictions. So one of them is that the Privacy Act is around the disclosure of information that might be secret to you. So that's sort of first two issues here, that the Privacy Act is about protecting you from the disclosure of information that might embarrass you or cause you some kind of reputational harm. And that bears with it, that kind of brings with it the implication that the Privacy Act, whether it's Australia or New Zealand, only apply to secret information. And to some extent, I think that's a consequence of the fact that we've called our laws the Privacy Act, and we think about private and our private lives as being something, I think, which is quite different to what the acts regulate, which is the protection of personal information. So we need to stop thinking about Privacy Act and what it protects in the context of kind of our private lives, and think about it more in the context of protecting personal information, and in particular personal information in whatever form and whether or not it is publicly available information. So a lot of people will say to me, this information is not covered by the Privacy Act because I got it off a website, or it was kind of included in some email that was sent to me, therefore it's been made public, and so it's not private information. So again, the name is misleading. The Act does apply to information in whatever way that you receive it, whether you collect it directly or whether you get it from a third party or it's shared with you from another provider. All of that information, it will be covered by the Privacy Act, regardless of its source, if it is personal information. So that's I think that's probably the starting point for us, is just to be aware of that the Privacy Act covers all personal information. It covers the collection and processing of personal information. So it doesn't prohibit anybody from collecting or processing personal information. It just puts some principles around how you should go about that. So there are some of the things that we're going to talk about right now. So one of the things as well that's worth bearing in mind is that this is a really difficult area of the law, and it's one of those tricky things because it's where law comes into play with people's values about this idea of what should be the right thing that you do in regard to handling personal information, particularly if you were looking at doing some kind of more sophisticated analytics or profiling, is where sort of some of these ethical issues and value-based issues come into play. And because privacy is reasonably new, or data protection is a reasonably new area, it really kind of became law probably only in the 1980s and 1990s. So we haven't had the hundreds of years that have gone into thinking about this area of law that have gone into other areas. So it is sort of a developing and changing area, which makes it a little bit difficult for you people and all of us, even our practitioners, to necessarily kind of work out what exactly what exactly is required by the law. So we're in a new area of law, and it is a law that is trying to support kind of community values, but we also have a situation where the community values aren't particularly clear. We see lots of conflicting behaviour between what people will do in terms of the information they make available and then what they say that they regard as important. So, some of the attitudes that people that people exhibit are kind of, as I said, a little inconsistent, and certainly we don't have a generally accepted kind of moral or value-based position in regard to the way that we handle personal information. So that just makes it more difficult for us. As well, I think it's worth recognising that we're going to be cultural differences around the world between different countries and different types of people, often linked to their historical and political background on the way that they feel that information should be handled. So again, as sort of citizens of an increasingly international world, we need to be cognizant of these differences in approaches and cultures, and somehow try and embed that into the way that we deal with people's personal information if we can. So I suspect that that's not particularly kind of heartening news for anybody, unless you're a sort of a philosopher or somebody who's interested in kind of tracing the development of kind of ethical approaches to handling of personal information. But the reality is that we're living in a kind of an uncertain, changing and developing area, and most of us will kind of be trying to look ahead into an uncertain world to put in place systems that we think are going to, be resilient enough when changes kind of come in. So privacy laws, we've got privacy laws in Australia and New Zealand, and I suspect that most of the people the organisations who've signed up to this webinar are probably going to be covered, certainly by the privacy laws of either country. So First of all, talk about the territorial application of privacy laws. And so the idea is that if you're an Australian organisation that's collecting personal data, you're going to be covered. You'll also be covered by the Australian privacy laws if you are going to be regarded as carrying on business in Australia. So that may mean that you may not have a physical location in Australia, but the way that you act in Australia may be sufficient for you to be regarded as carrying on business. So questions are, it's just targeting or emailing donors or potential partners. Is that going to be sufficient to mean that you're carrying on business in Australia if you're a New Zealand organisation? Or is even just having an accessible website sufficient? It's been said for a long time that just having a website is probably not sufficient to be carrying on a business. If people can get onto your website from Australia, for example, if you're a New Zealand organisation, if they can access your website and make donations or support you, then that probably isn't sufficient for you to be regarded as carrying on business in Australia. But it's worth kind of thinking about Ashley Madison, which I'm sure most people will probably remember Ashley Madison. That was the cheating website that there was somebody who was, I think, a little bit antagonistic towards their business model and who ended up hacking the site and publishing the details of a lot of the clients, in inverted commas, of Ashley Madison. And it was then when there was a long investigation that was led by the Canadian Privacy Commissioner, because Ashley Madison is a Canadian company. So it's a Canadian company, all of its physical servers, network, everything, all of its people were based in Canada, but it marketed to Australians. So it had ads in Australia. It was clearly targeting Australians, and it actually had a lot of Australian customers. So the Privacy Commissioner said that the fact that Ashley Madison had taken some more active steps than just having an available website via its targeting and advertising, that meant from a privacy point of view that Ashley Madison is going to be carrying on business in Australia. So first point, if you're an Australian organisation, you're going to be covered by the Australian Privacy Act, although there are some exemptions we'll talk about next. If you're a New Zealand organisation, prima facie, you're not carrying on business in Australia unless you're doing something kind of proactively to target Australians, which then might mean that you've got two different regimes that you have to think about, which is when it starts getting complicated. And then to put all of this in the kind of the context of the European privacy laws that we spoke about last time, I think I gave a presentation here. We were talking about the General Data Protection Regulation, or the GDPR, and in Europe they've kind of gone a step further, I guess, and made it really clear in the legislation that if you're providing a good or service that targets people who are in the EU, then you are going to be covered by the European Data Protection Regulation. So that's certainly the direction that Europe is going, and perhaps the direction that other regulators would go as well. So perhaps a rule of thumb is that if you go out of your way to target international donors or partners or clients, then that may mean that you are going to be considered to be covered by that other jurisdiction's privacy laws. So in Australia, as I said, there is some, the application, other than the territorial application, is pretty broad. It applies to Commonwealth government agencies, individuals, and all other sorts of legal entities, including trusts and unincorporated associations. And I suspect that some of you may fall into that category. So just to talk about Commonwealth government agencies for a second, in Australia, the Privacy Act is a piece of federal legislation, and it doesn't apply to state government agencies. So service providers to state government agencies are going to come under the state privacy laws, to the extent that there are state privacy laws. So a couple of states in Australia don't have any laws, which is an entirely different discussion. Similarly, in New Zealand, they use a slightly different term in their Privacy Act, which they talk about agencies, but that again has got a very broad definition to cover all sorts of kind of different legal entities, including individuals, so government departments, companies, social clubs, and any other type of organisation. So there's no exemption per se for charities or for not-for-profits from the Privacy Act. You will be covered. There are some exemptions. The idea that individuals, or if you're collecting information just for your own personal use, so if you are keeping information for the to do the school tuck shop or to do the your soccer club or something like that, then that will be outside the operation of the Privacy Act. Political parties and journalists in various forms are both exempt in Australia and New Zealand, and that's why we are lucky enough to receive the correspondence and phone calls that we do from members of Parliament. There's a strange exemption in Australia for small businesses. So if you are less than $3 million per annum in your turnover, then you are covered, but you are then brought back in again if, for example, you collect health information. So it's a bit of a tricky one to rely on that carve out. So just if you are a small not-for-profit or particularly anybody who provides any kind of health service, you need to be a bit careful about relying on that exemption. In any case, given that conversation that we had in that first slide about societal attitudes and the growing kind of international nature of privacy laws, I'm not sure that it's wise to rely on an exemption in terms of the systems that you should put in place to protect the personal data that you collect. So as I said, similar exemptions in Australia. Also, the state government agencies applies also to contracted service providers to state government agencies. So if you're providing a service pursuant to a contract with a state government agency, then you will come outside of the operation of the Federal Privacy Act and you'll be brought within the operation of the state privacy regulation. So that's a big area, and if anybody's got any questions about them, shoot them to Tina and we can kind of follow up with that later on. It does make it a very complex area in Australia, and ideally it would be a great thing to have a single set of privacy principles that apply to federal and state agencies as well as other entities across Australia as they do in New Zealand, but unfortunately we don't seem to be able to get there. So a couple of other things that might be worth mentioning depending on the way that your organisation is set up is that in Australia there is a exemption for the sharing of organisation within the same corporate group. So if, for example, you are maybe the not-for-profit part of a broader corporate group, there is a right to you to share in the information that the rest of the group might collect about their customers. For example, you might be the foundation that's part of that's linked to a hospital. In principle, under the Australian Privacy Act, you can share the information around about the patients can be shared in principle with other members of the same corporate group, provided that there's a kind of a shared overarching controlling interest. But the purpose of collection of that information kind of goes with it. So the information was collected, to provide a health service. Then you, as the foundation or the charitable arm of your health service provider, need to think whether or not you could use it for marketing purposes. So just remember that you can actually access it, and that can be very helpful, but then you just need to think about whether the use of the information for marketing purposes is going to kind of be part of the initial purpose. And we'll talk about that a bit later when we're talking about purpose of collection and secondary purposes. This exemption doesn't apply to overseas transfers. So if you're transferring your information to maybe the headquarters of your group that might be in a different jurisdiction, then you've still got some restrictions around transferring information outside of Australia. So that may be of some interest to somebody. One of the other questions that comes up is what happens if you have somebody who goes rogue, and I know that this can be an area of concern because of the number of volunteers and changeover in staff that can happen. So in principle, the organisation is going to be liable for its employees unless you can establish that you had appropriate privacy practices in place, and that what went wrong was like a one-off human error that your systems couldn't have addressed. So this puts the onus back on you to make sure that people are appropriately trained, that you have appropriate systems in place to make sure that you look after personal data, so that if something does go wrong, your organisation isn't going to be held liable for that, for that particular act. So again, if that's something of concern to people, we can talk more about that. So getting back to, again, one of the key issues for privacy or the Privacy Acts in Australia and New Zealand is that it applies to personal information. And so it's important as a threshold issue to identify that the data that you're talking about falls within the definition of what is personal information. So fortunately, the definitions in both Australia and New Zealand are not dissimilar. It is about information about an identifiable individual in New Zealand, and in Australia, we talk about an identified or an identified individual or an individual who's reasonably identifiable. So this idea of identifiable means that you may not in the group of data that you have be able to identify a particular individual, but if that information can be matched to other information, for example, if you have a health identifier, that means that you can match that data to other data that will give you details about that individual, then the data set that you have will be regarded as personal data, if that makes sense. Sorry. So you need to think about all the other information that you might hold and whether that can reasonably be aggregated, and if it can, then the data, even if it's not by itself sufficient to identify an individual, will be regarded as information about an identifiable individual. So think about that with all the different data sets that you use, particularly if you are kind of cutting and dicing the data that you hold to do analytics or to share it with other parties for research or to do analytics about the kinds of things that your clients or potential donors might be interested in. So there are some bits of information that are clearly going to always be personal information. So things like email addresses, phone numbers, any kind of contact details, a photo, CCTV videos, a photo of somebody is always means that you can identify, isn't it? There's information about an identifiable individual because you can identify a unique individual from their photo. And so think about that in terms of taking photos of events or photos of your clients or in publishing newsletters, that will all involve the collection and use of personal information. Obviously, financial information, although that isn't given any special treatment under Australian or New Zealand law, but that is information that, if disclosed, can have a significant financial consequence. So you need to think about that in the context of data breaches. Where information may get more kind of potentially harmful as well as details of the particular interactions that your agency might have with an individual, even if that is stored in a way that is not immediately identifiable. Again, think of this idea of whether it is reasonably identifiable. Is an individual reasonably identifiable by being able to kind of correlate that data with other individuals? One of the principles in the Australian privacy and in New Zealand, is also the idea that you should give people the opportunity to interact with you in a pseudonymous or anonymous way, if that's at all possible. So if your clients are coming to you maybe and seeking some initial assistance, it might be that it is appropriate for you to think about whether you can do that in a way that involves the an anonymous interaction. So Australia has extra kind of rider on top of this idea of personal information, this very broad idea of the type of data that's going to be personal information, and talks about sensitive information, and that's information that is around particular characteristics of individuals. So it's not information necessarily that relates to financial harm, but it's information about people's racial or ethnic origins, political opinions, religious beliefs or affiliations. And clearly a lot of this information is going to be information that that a lot of the people on this call, I'm sure, would be collecting as part of the services that they provide, particularly about their clients. It might be that you're required to collect some of this information as part of the services that you provide as well. But any of this information, if collected, is going to be regarded as sensitive information, so health information as well, genetic information, biometrics. And there are much more stringent rules in Australia around the collection of sensitive information. And by and large, you shouldn't collect information unless the individual kind of consents to it. So one of the difference between Australia and New Zealand, and we'll talk about, we'll summarise the differences at the end, is that the New Zealand Privacy Act doesn't specifically regulate sensitive data, but it has got specific regulations, for example, about health information in the Health Information Privacy Code. So even though there isn't anything specifically around special treatment for sensitive data, I think that these ideas that you should be kind of especially cautious about way that you collect and process any of the type of information that falls within those kind of categories that we talked about. So people's health information, their religious, political beliefs, their racial, ethnic information, their sexuality, the same kind of idea should apply in New Zealand as they do in Australia. So a little bit about privacy policies. So privacy policies is the published information that you provide to all of your stakeholders, your clients, your providers, the people who might, your donors, about the kind of the information that you collect and how you handle it. And this is the best opportunity for you as an organisation to demonstrate the way that you value and sincerely kind of want to protect the information that you get. So I can't kind of stress enough, I think, about how valuable it would be to have a clearly written and an understandable privacy policy that tells kind of your constituents about, what your attitudes are towards the handling of personal information. So we know under the GDPR in Europe that they are pressing for much greater transparency. There's definitely a move away from having, many pages of densely written legalese that you need a PhD to understand, to having stuff that is actually targeted at your users. So if you are dealing with kids, then you need to think about whether what you're writing is going to be understandable to kids. Or it needs to be presented in a way that parents can explain it to kids. You need to really seriously think about that. Think about who your audience might be, and make sure that what you present to them is understandable and appropriate for that particular audience. And as I said, a couple of the not-for-profit organisations that we've worked with, where we've unpicked and just started again on their privacy policy, has made a really big impact on them, because it sort of helps them as well make that connection between the way that you handle personal data and the ethics or the values that you as an organisation have. And that can be very powerful for you internally, but also for your employees as well, because you need to kind of use get all of this kind of idea of how you're going to treat the personal data of people embedded throughout your organisation, and develop a real culture of respect and trust and valuing of people's personal data. So there's some guidance that's available from the both the Australian and the New Zealand Privacy Commissioner that we recommend that you have a look at, and we're trying to put together a list of good privacy policies that you guys can have a look at, because there aren't a lot of them out there, and I know that it can, it's with the number of things you have on your plate, like writing a new privacy policy from scratch is probably not the top of your list. As I said, think about what your stakeholders expect, and ask a few kind of simple questions. And as I said, the people that we've dealt with have had a kind of quite powerful reaction when we have been able to recast what's been a jumble of legalese into an important kind of foundational document for them about the way that they handle personal information. So, and the other thing with that from that slide as well is make sure that you stick to what you say that you're going to do. Again, I'm not suggesting that kind of making sure that you don't get in trouble from the Privacy Commissioner should be your number one requirement when you're thinking about what you should do in terms of dealing with personal data, but it's certainly something to bear in mind. And doing a review of privacy policies is something that privacy regulators do quite regularly. So the Australian Privacy Commissioner has done it in the past. The various regulators in the EU have done it. They can easily do a sweep of privacy policies and run them through a readability score, and then give feedback, which can be kind of good or bad on the readability of your privacy policy, and also just checking that you do everything that you say in your privacy policy. So, if you've just nicked a privacy policy from somebody else, it might be time now to just think about just having a look at it again and making sure that it is aligned with your culture and values, and as well that you do all the things that you say that you do in that policy before the Privacy Commissioner comes knocking on your door. There's a particularly good article that was published in the New York Times in the last couple of weeks, where they did a review of 150 of the biggest policies of the biggest privacy organisations like Airbnb, Uber, Facebook, Google, I think the BBC, and they found that most policies require the like a tertiary, a post-tertiary, like a PhD type level of education to understand it. So not a good outcome still for people who are trying to lead in the privacy space. So, as I said, the Privacy Acts in Australia and New Zealand don't prohibit the collection or use of personal information. They just give some guidelines or some principles around the type of information that you can collect and the sorts of things that you're allowed to do with it. So, in Australia and New Zealand, you can collect personal information, but only if it's necessary for one or more of your functions or activities. So you can't collect information if it's extraneous to what you're doing, basically, but provided it's necessary for the services, as part of the services that you add or the services that you provide, then it should be reasonably straightforward to demonstrate that you need that information. But again, think about the extent of the information that you collect. If somebody signs up to your newsletter, for example, do you really need to get their first and last name, or is it enough to just get their email address? That may well give you their first and their last name, but often it doesn't. So in all cases, it's worth remembering this kind of principle of data minimization, which is a principle that's now been introduced in Europe. And so the idea is kind of minimize, think before you collect information, and try and minimize the data that you collect, because ultimately the less personal information that you hold, then the less kind of burdensome it is in terms of making sure that information is accurate and protected correctly, and that it's being processed in the appropriate way. So try and minimise what you collect, and make sure that when you do collect it, that it's necessary for your purposes and activities, or not just something that you think might become useful at some stage in the future. So we've had some examples in Australia of what the Privacy Commissioner doesn't regard as reasonably necessary. So one of them, the one where the medical practitioner was taking the photo, that was a case where he was taking the photo just so that he remember who the individual was. So it wasn't kind of a photo of the particular condition or anything that was related to the actual health service. It was just because his memory was bad, and he wanted to have record in all of his files of the individual so that he would remember them. So that was the basis for that one, which perhaps may be one of those little line ball ones. But again, maybe a useful example of some of the situations that might arise where you think it will be perfectly okay to collect information, but if you put yourself in the shoes of the individual, then maybe it's not such a great idea. So again, some other instances there. So again, remember, in Australia we have specific provisions around that group of information that's sensitive. That you can't collect it unless you get the consent and the information is reasonably necessary for your organisation's activities. Sorry, I think I might have just, did I lose audio?
Hi, Jody. Just dropped out for a second there, so we missed that last section that you spoke about.
Okay, thanks, Tina. Sorry about that. I think it's been one of those days today. The internet seems a little bit up and down, so I apologise. So sensitive information, again, there are specific limits around what you can collect under the Australian regulation, but it's probably worth thinking about these in New Zealand as well. So either you have to get the consent prior to the collection, and the information has to be reasonably necessary for your organisation activities, or if you're a not-for-profit organisation, you can collect it if the information relates solely to your members or the individuals you have contact with. So again, that probably provides a bit more leeway for not-for-profit organisations in terms of the sensitive information that it collects, but again, be careful. So the requirement to get consent may be problematic, particularly if you need to get that consent before you collect the information. Yeah, and this is a kind of a whole, this is a quite a big area that we probably don't have time to go into a lot of detail today. But again, just be aware and cognizant of that. So.
Sorry, Jodie, you've dropped out again.
Dropped out again. Yes.
Yes.
Sorry about that. Yeah. Okay. Maybe it's this slide. Maybe I'll move on. So the gist is that generally, if information is reasonably necessary for the purposes of your business, you can collect it unless it's sensitive information. If it's sensitive information and you're a not-for-profit, then you can collect it provided it relates solely to the members or individuals that you're providing the services to. Otherwise, you have to get consent before you can collect that sensitive information. So consent. Sorry, Tina, is that still, oh gosh.
Okay, I can see the consent slide now.
Okay, sorry.
That's all
Gosh.
right.
Oh, so consent is getting a little bit harder, right? So traditionally we've relied on things like a pre-tick box or implied consent or a bundled consent, where you get people to consent to a whole lot of things, like the ones that we all see when we sign up to get a mortgage, and the bank says you consent to us, using your personal data to process your loan application, to share it with any third parties that we might think that need it, and to keep it and do analytics, and to give it to and do with it whatever you like. And that's all kind of bundled, and if you don't say yes, then you're not going to get your mortgage. So we're moving from that kind of situation now to consent being much I think being much much clearer, I guess. So there are different ways that you can get consent. So it can be that you get somebody to sign a form, or you can get somebody to kind of agree in person, which might be if you are talking to them over the phone and you need to get them to kind of confirm that they're okay with you collecting and recording their sensitive information over the phone. Or you can use some kind of other online medium, like the tick box or the online consent form, which is the one that we're probably most familiar with. So in most instances, as we said, within Australia, you should get express consent. So that means that you need to get some kind of positive express action that indicates consent. You can't rely on it being implied from people continuing to use your service, for example, or the fact that they didn't object. So this idea of express consent requires this idea of a positive, some kind of positive action. Oops, sorry, just went backwards there. And the EU talks about consent as it having to be specific, voluntary, unambiguous, and freely given. So all of those things should be things that you should think about when you're trying to construct, or if you're relying on kind of consent to the collection of sensitive information in particular. In Australia, we have an extra provision on top of us having to give that privacy notice or privacy policy that we were talking about previously, where we have to provide notice of collection whenever information is collected from an individual. So we have to make them aware that we're collecting their personal information. So this is a somewhat different. So this doesn't apply in New Zealand, but what this would mean in effect is that if and when you're collecting information from people, you need, as well as making them aware of your more general privacy policy, you also have to give them specific information at that time of collection about what you are collecting. So that includes the kind of information that you're collecting, and what you intend to do with it, if you intend to send it overseas, and a couple of other bits of information. So just be aware of that as an additional requirement that applies to Australian organisations. And it's not a bad policy to think about for New Zealand organisations, because it really improves and adds to the transparency, to your transparency, if you provide this additional notice of collection in addition to your privacy policy. So we've talked about the information that you can collect, and it being reasonably necessary for the purpose of your business. We talked about if it's sensitive information in Australia, you either need the express consent of the individual to the collection, or you need to, if you're not for profit, it has to be in regard to one of your members or the individuals to whom you're providing the service. So having collected it, what might you be able to use it for? So largely you can only use or disclose personal information for that purpose for which it was collected. So you need to be clear on what was the purpose of collection, and you need to make sure that that purpose attaches to the information and you don't use it for any other purpose. So the provision is largely the same in Australia and New Zealand, so that's a kind of an area of consistency. So there's a lot of discussion about what's a use and what's a disclosure, but it's basically sort of anything that you might do with information might be a use or a disclosure, and this will get more important when we are looking at transferring or disclosing information outside of Australia. But it's also worth thinking about when you are thinking about dealing with third-party providers, is what you're doing with that third-party provider, that cloud service provider, whether they're providing you with some kind of software as a service platform, or some other maybe data analytics service or a marketing service. Is that a use or a disclosure, and would that use or a disclosure be allowable in the context of the purpose of the original collection? So there's some of the things that you need to think about. So those sorts of things that we just talked about may well be regarded as a secondary purpose. So you, for example, might collect in your organisation information about people who come to your health clinic to get a service, and then the question is, are you able to market to those people to get them to support the provision of the services by your organisation? And would that purpose, that marketing purpose, would that be regarded as something that was part of the original purpose, or would it be regarded as a secondary purpose? So a secondary purpose is generally something that you can't use information for unless you kind of meet these criteria there for Australia and New Zealand. Again, they're much the same, although worded a little bit differently. So in Australia, you can't use personal information for a secondary purpose unless you've got the consent. And the consent in this case may be implied consent, and that's kind of covered by the second bit, where you can use it for a secondary purpose where that secondary purpose would be kind of within the reasonable expectation of the individual. So if you buy something from somebody, or if you get a service from an organisation, it's probably within your reasonable expectation that organisation is going to contact you about other services that they may offer, or improvements that they've made to the service, or maybe other ways that you might be able to benefit from interacting with that particular organisation. So that's where this sort of, is it within the reasonable expectation of the individual kind of becomes a key question. One of those ways where it can be within the reasonable expectation of an individual is if you've made that clear in your privacy policy, for example. If you've made it clear that you're going to use their personal information to provide them with information about other products and services that they may be interested in, would be a way of making kind of clear or establishing that reasonable expectation. Again, though, there has to be some relationship between the primary purpose and the secondary purpose, and there are specific restrictions around the use of information, use of sensitive information that you just need to be aware about again. Australia's got some special information, some special kind of rules around marketing that we'll just talk about here. So marketing is generally regarded as a secondary purpose, and this was something that was given a lot of consideration to when we changed the updated Australian privacy principles in 2014 that ended up coming through in 2018. And we've basically kind of made it easier to market to individuals in Australia by including an APP7 that applies to direct marketing. And so where you're looking at direct marketing, you don't need to think any more about whether or not that would be within the reasonable expectation under APP6. You just look at APP7, and APP7 talks about direct marketing, and it differentiates between whether you've collected the information directly from the individual or whether you've got it indirectly or from a third party. So the direct collection is probably pretty straightforward. It's where the information has been provided to you by an existing client or somebody who signed up to a newsletter or other marketing interaction or some event that you've run, or somebody who has maybe previously donated to you. So all those people, it is expected that they have a reasonable expectation that their personal information will be used for marketing. So you can market to them if you've collected that information directly, but you have to provide a simple means to opt out. And the individual obviously has not exercised that option to opt out. So where you've collected information directly from individuals in Australia, it's pretty easy to market, to do any direct marketing to them. All you need to do is to have a simple opt out. If you collected the information indirectly, and that might be where, for example, you have been given the names by a third party, where you might have run an event with a third party, or where another organisation has shared the information with you, or you have gathered the information yourself from LinkedIn, for example, then there is no reasonable expectation that information is going to be used for direct marketing. So you can't use or disclose the information for direct marketing unless you come within the exceptions. So you can still use it for direct marketing, but you just have an extra step where you have this indirect collection idea, and that is that you have to include a statement telling the individual that he or she may request to no longer receive direct marketing. So that's just, you can still use information, you just have that individual, that sort of that additional step of having that clear statement that individuals can request it and then have the opt-out the same way that you do where you had the direct collection. So not an incredibly onerous set of conditions under the APPs in Australia in regard to the use for direct marketing. So as I said, they in some ways have made it easier to directly market to people under the privacy laws in Australia. So if you're in New Zealand, you need to think back to that secondary use. Would be the use of personal information for marketing be an acceptable secondary kind of purpose? And so you need to think about what the connection is between the original purpose of collection and what you propose to do with it now. So the other thing to think about when we're talking about marketing is, in addition to privacy laws, we've also have anti-spam laws, and in most instances the Privacy Act says that it will be subject to any more specific laws. So the anti-spam laws will override the privacy laws. So the anti-spam laws generally in Australia and New Zealand are the same. They cover the sending of kind of commercial emails, and unsolicited commercial emails is what they're talking about. But they also cover all sorts of commercial messaging, so by SMS as well as by email. So all of those things come within these anti-spam laws. And it might be that solicitations for example, participation in an event may be regarded as an email or a message of a commercial nature, which might bring your organisation within the anti-spam laws. So in Australia, registered charities are exempt from the anti-spam laws. So that means that in terms of your marketing communications, you are back under the Privacy Act, and just think about those provisions under APP7 about direct and indirect collection, and just making sure that you have the statement or the opt-out, depending on the reasonable expectation, and the anti-spam laws don't apply to you. You still have some obligations though to include accurate sender identification in all emails, including your contact information. New Zealand, there is no exemption for charities. However, there is this exception for marketing or promoting goods or services. So the argument is that if you're not promoting, or if you're not marketing or promoting goods or services, if you're seeking donations or seeking support for your not-for-profit organisation, then that may not be a commercial email within the context of the New Zealand anti-spam laws. So a less clear situation in Australia, but a pretty clear, so less clear in situation in New Zealand, but reasonably clear in Australia, where registered, you have to be a registered charity to be exempt. Otherwise, you'll be covered, and you need to think about whether or not your emails are going to be commercial emails in the context of marketing or promoting goods or services. So some of the things that you should do if you are covered by the anti-spam laws is to seek consent where you don't have inferred consent. So consent where it's somebody that you may not have a pre-existing relationship with. Make sure that you always identify yourself so that people understand who the email is coming from, and make sure that you provide an unsubscribe button. So even if the anti-spam laws do apply to you, these are the things that you should do with your marketing, any kind of marketing communications that you have, and it's probably good practice to comply with all of these requirements, as I said, regardless of whether or not you are formally within the spam rules. So just good kind of hygiene, I think, and making it clear about who you are, and making sure that you don't tick people off, which is what you want to do, is you want to make sure that people stay engaged and support, and you don't tarnish your brand out in the marketplace. So a few observations about cloud service providers, because I know a lot of organisations will be using the cloud to provide them with services, because it is going to be more efficient, and it helps kind of give you all the services and the sophisticated marketing and support tools that you can't build in-house. So have a think about your cloud service providers, particularly in the context of the data that you might be hosting with them. There can be very sensitive information about people's individual circumstances that it just may not be appropriate for you to share in an unidentified state, or in an identified state with a cloud service provider. So before you do any kind of large engagement with a cloud service provider that might involve the sharing of personal data, then I really encourage you to do a privacy impact assessment, to just go through what all the implications might be, and to make sure that you have the appropriate controls and risk mitigators in place if that's at all possible. So as a starting point is sort of think about, is it appropriate for you to share the data that you're thinking about with a cloud service provider? Is that an allowable use? And that may kind of just go back to having a look at what the cloud service provider might do with it. I know a lot of free services in particular are going to have provisions in them that allow the cloud service provider access and personal use of your data, and that may not be something that is allowable in terms of the purpose for which you collected it. That might become an unexpected secondary purpose that's going to be outside that original purpose. So just be really clear about thinking about the data and the risks that might be involved before you adopt a cloud service provider. And then also have a think about the actual cloud service provider that you're looking at. It's not necessarily just a financial fit. Have a think as well about the cultural fit. Is it the kind of organisation that you think are going to match the organisation that you are and respond in the way that you would expect from a cultural point of view? Often you can get a sense of that from who their other clients are. People used to be interested in who the other clients of cloud service providers might be, to give a sense of whether or not those cloud service providers were going to be attacked. But there's probably some benefit in doing a little bit of digging on what the kind of target market of the cloud service provider is, to make sure that it's, as I said, somebody that is a good fit with your organisation. There's lots that's been written, there's lots of resources available about doing security reviews of cloud service providers, and that might be one of the reasons why you decide to go with a cloud service provider, because often they are able to put in place security provisions that you can't, but you still need to do a bit of digging about how they are going to look after the personal data, how they're going to respond if there is a data breach, and in particular think about where the data is located, and think about the kind of staff that might be there in that location, and from a practical point of view, are they going to be properly paid and managed and recruited and checked, and if not, what the issues of that might be. Contractual issues to some extent, can be covered by procurement or will be included in standard contractual clauses, but there's still some really, really important things to think about in terms of limiting the cloud service provider's right to access or use the personal data that you might be hosting with them for any of their own purposes. It really must be limited. You really must limit their right to access or use it just to the purposes of providing the service. And then make sure they can help you if, for example, you need them to support you in giving access to individuals or for other types of individual rights, and what happens at the end of the term of the contract. So one of the reasons in particular that I've been talking about cloud service providers is a lot of times the cloud service provider is going to be hosting your data outside of Australia, and that is because of it's going to fit into the economies of scale and the efficiencies, and mean that kind of helps you with the pricing. So you need to think about under Australia whether you comply with APP8, which is about disclosing personal data outside of Australia. So generally, there are restrictions on disclosing personal information outside of Australia, and generally the rule is that you have to ensure that the overseas organisation doesn't breach the APPs or complies with laws that are significantly the same as the Australian APPs, Australian Privacy Principles. So if you need to do that, and you can't send the data outside of Australia unless you've done that. And even if you do that, in most cases, you will still be liable in Australia for a breach of the Australian privacy principles by your offshore service provider. So this is another reason I think that you need to be careful to make sure that you've done your due diligence and you've got an appropriate cloud service provider, because you may well be on the hook for the actions or failures of that cloud service provider in Australia. So think about all of that. New Zealand is a little different. They don't have a specific provision that says that you can't transfer it outside of New Zealand, but it's clear that you will still be subject to the same principles in terms of making sure that the information is secured and that it's accurate, and that you don't retain it for longer than you should, and that it's disclosed only for the appropriate purposes, etc. All of those limitations will still apply. So in a little bit of a more indirect way, you still really have the same obligations, even though there's not a specific thing that applies to cross-border disclosure, but you do have the same kind of obligations in New Zealand to make sure that any third party to which you send your data is going to comply with the same laws or the same principles that apply to the data in New Zealand. So the same kind of considerations ultimately will apply. We won't do this practical exercise, but I'll just kind of try and finish up by quickly talking about data security and breach obligations. So I think in Australia is getting a fair bit of headlines at the moment. We're seeing quite a few significant breaches affecting not-for-profit organisations, and particularly some health service providers. Health service providers are the top category of organisations that are affected by data breaches in Australia, according to our AIC data. So they're, again, it's possibly a consequence of the amount of data that they handle, but they certainly are, have a large area of exposure. Similarly, we've seen some large data breaches affecting education providers. Big universities in Australia have had some significant breaches lately. So security and data breach, I think, is probably a bit top of mind for everybody, and making sure that you have appropriate systems in place is a good idea. So APP 11 in the Australian APP says that you have to take such steps as are reasonable to secure it, and if second part is that if you don't need it for the purpose for which it's collected, you should destroy it or de-identify it. So that fits into that data minimization principle I was talking about before. So you have a positive obligation to make sure that the data you have is secure. You also have a positive obligation to make sure that you delete or de-identify data that you no longer need. So similar provisions in New Zealand, they have very similar privacy principles, which is a kind of a key privacy principle that applies to almost every country that's got a privacy regulation, is that obligation to take reasonable steps to secure it. In Australia, we've introduced a data breach notification regime that is triggered by you having an eligible data breach. There are two parts to there being an eligible data breach, where you have to have some kind of unauthorised access disclosure or loss, and it has to be in circumstances where there's a likely risk of serious harm. So this likely risk of serious harm is a kind of the key consideration, where you need to think about whether that the risk to the individuals whose data has been accessed is likely to be serious harm. So again, that's the million-dollar question for organisations in Australia. There are a couple of exceptions where you don't have to notify. One is if you take remedial action. So if you do something after the data breach to make sure that you mitigate the loss, there's no likelihood of serious harm anymore, then you don't have to notify. So that's, for example, remotely wiping a lost laptop or other kind of mobile device is an example where you can kind of mitigate the data breach. There are also some provisions around suspected data breaches, which gives you some provision to do an investigation, but again, it's a whole separate topic that we can have. So notification generally has to be as soon as practicable. There are requirements about what you need to include in your notice. There are also requirements about who should be notified and how they should be notified. And again, we can provide further information about that if anybody needs it. So New Zealand is currently thinking about data breach. It's been on their radar for some time. I guess data breach has been a little bit controversial. It's not entirely clear that it has the kind of outcome that people expect. So I think that's one of the reasons why it's sort of still on the agenda. In the meantime, the Privacy Commissioner has made it clear that although there's no legal obligation, they think that voluntary notification is a good idea. And voluntary notification should be considered one of those steps that you might take to secure your data, because voluntary notification to individuals will give them the opportunity to mitigate any particular loss, and mitigating the potential loss is a way of kind of dealing with the consequences of a data breach. So although there is no direct obligation to notify, if you don't notify and it turns out that if you had told people they would have been able to protect themselves from the harm, then I think that you might still be in trouble in New Zealand under the security provision. So, as we've said, the Privacy Commissioner in New Zealand is certainly supportive of voluntary data breach and has published some resources that are worth having a look at, their guidance on responding to data breaches. So there is some expectation that the mandatory data breach reporting will be introduced. It is not dissimilar to Australia in that the trigger is likely to cause serious harm. So that's the same sort of trigger as we have, and so it might be of interest to people in New Zealand to have a look at the kind of breaches that have been reported in Australia, that the Privacy Commissioner here is publishing kind of statistics and information about that. The time is about the same, as soon as practical after becoming aware of it, the notification, who is notified, and the type of information to be included in the notification, again, is not dissimilar to that in Australia. So if you're building a data breach response plan, which you definitely should have if you don't already, then that should cover both Australia and New Zealand, and there won't hopefully be that many dissimilarities between the two requirements in terms of the regulators. So for people who have a mixed, extend into both jurisdictions, then hopefully the same data breach response capability will cover your obligations under both bits of regulation. So just to finish off, There are lots of similarities between Australia and New Zealand, and I think that there are sufficient similarities for you to be able to develop a privacy program that meets the requirements of both. The territorial applications, the definition of personal information, the requirements in terms of your published privacy policy, the restrictions around collection and use of personal information are all pretty much the same between the two countries. We also have similar spam laws and the requirements to be able to send a commercial email. We do, of course, have that exemption for charities in Australia. Things that are a little bit different is that Australia has this weird provision around state government contractors. It's also got the small business exemption. We have the treatment of special treatment for sensitive information, and we've got that specific provisions around marketing, which make it kind of easier to market in Australia than you do in New Zealand. Some specific provisions around transferring outside of Australia, but we've probably got the same kind of provisions in New Zealand, and a slightly different regime for data breach notification in Australia, but we suspect that New Zealand might become similar in the not too distant future. So, as I said, not entirely dissimilar regimes, and they should fit together pretty well when you are putting together a privacy program. So that is it. I'm sorry that was quite a lot of information in quite a small period of time, but I know that Tina's going to make the recording, which will include all the slides available, and we're happy to answer questions if there were any, Tina.
Yep, we've had some questions come through. The first one is, what do you mean by collecting information? Is it okay to ask for information as long as it's not mandatory? For example, you don't need a first and last name for sending out emails, but is it okay to ask for these but have them as optional fields, or are you not meant to ask at all?
That's a really good question. Yeah, that is a really good question. So, I guess it's a question of the kind of the potential use. So you could say in sending out newsletters that you'd like to get the first or the last name because it would be useful to help you personalize the email, so you can send it out to Dear Jody. So if you make it optional and if you provide a clear notice of collection of the information and a link to your privacy policy, then that's okay. Where it would get problematic would be if you start asking for information like people's telephone number, for example, because you don't need anybody's telephone number to send them an email, and that's where I think telephone numbers are becoming like a de facto identifier. Once you get a telephone number, it makes it much easier to kind of start aggregating information about the individual. You probably don't need their street address. You definitely don't need to have information about their political or religious beliefs. So there is some information I think it's okay to make optional, provided, again, the overarching kind of idea is that you can only collect it if you have a purpose, if there's a purpose that's reasonable, that's kind of related to your business. So that's kind of the overarching thing. So you can collect it, but it's best practice not to collect it if you don't need it. That's a pretty roundabout. That was a pretty roundabout answer. Do you think that helped?
Okay, next question is, what if the CSP provider is used for data collection, for example, online data collection forms? Is this considered disclosure?
Wow. Okay, that's a good one. Are you disclosing? So the cloud service provider you would be using would be collecting the data on your behalf. So yes, it probably would be regarded as a disclosure if that cloud service provider is overseas, because they're kind of acting as your agent to collect the data, and at some stage, which means that you're kind of directing them to collect it overseas. So the question about disclosure is kind of what that cloud service provider can do with the data. If they're going to be doing any kind of processing of it themselves, if they're going to be kind of doing data analytics or aggregating it with anything else, then or have any kind of right to access it or any control over the data, then it will be regarded as a disclosure. But if you're directing them to collect the data on your behalf, and it may just be kind of a use by you, but the downside of that is that you will be liable for any failure by that cloud service provider. So you'll be liable if they for any misuse of that data. So it's quite a complicated discussion, and maybe it would be rather than opening up that whole kind of cloud service providers and dealing with them, it might be better to have that as kind of a separate topic. Yeah, the interrelationships between the different types of cloud service providers that you can use, and whether you use them to do a survey for you, or to host data, or a software as a service, or as a CRM kind of provider is it's all different, and it's all kind of quite complex. So maybe I shouldn't have opened up that can of worms.
The next one is the use of Google Sheets considered disclosure?
Well, that's a good question. I'm not sure. We can have a look at that. I think it might depend on whether you're kind of using a paid for or not paid for. I don't know. I might just ask whether Tom, who's my offsider, who's on this call, whether you've got anything more about Google Sheets. I think that yes, I'm not entirely sure. It may well be if Google, in its background terms, has a right to use the data, or to, and it often does have the right to kind of do data analytics, or to kind of run, its tools over the data that or the information that you're kind of using.
Okay. Is there a specific act for health information in Australia that we should comply with?
Right, that's a great question. So the Australian Privacy Act covers both personal information and health information. So there isn't, at the federal level, there isn't any separate act that regulates health information. There is, however, the My Health Record Act that most Australians will be familiar with, and there's regulation that goes around setting up our e-health system. So if you are any health service provider who's interacting with that electronic health system, then there's that regulation, and that's got specific provisions in it around similar principles to Australian Privacy Act, and specific data breach notification obligations, etc. So the My Health Records Act at the federal level, but a lot of the health services in Australia are delivered by the state government agencies. So each state government will have regulation around the delivery of health services, and within that there are often provisions around the confidentiality of patient records and what you can and can't do with patient records. So it is a very complex world in Australia, with the state and federal systems and the way that they separately deal with patient records. So I'm sorry about that. And so again, remember that if you're a service provider to a New South Wales government hospital or health service provider, you're going to come under the New South Wales government regulations. For example, the New South Wales State Privacy Act, and any kind of relevant New South Wales state health regulation, which usually are incorporated into the contract that you have for the provision of those services.
Okay, next question is, what about sending a list of names and postal addresses to a printing press? Do I need to disclose this in my privacy policy?
Yes, so that is the sort of thing that you disclose in your privacy policy, but you would probably do it in a way where we use third parties to help us in the, in delivery of services, including, printing. So you don't need to be hugely specific about it, because that's the sort of thing that people would have some kind of expectation would happen, but it's definitely the sort of thing that you should refer to, yeah.
Okay. Are there any laws about the time frame of how long I can keep PI? Any difference with sensitive information?
That's a great question, and it's a great question. I think that's one of the things that is really exercising the minds of lots of people at the moment. The European laws now require organisations to specify how long they're going to retain different types of information. So a lot more thought is going into the retention periods for different types of information. But under the Privacy Act, there's no specific requirement in terms of the amount of time that you need to keep anything. So in Australia, you need to then look at the type of data and whether there are any kind of sector-specific requirements. For example, we know that there are requirements to keep financial records for a certain period of time. There are requirements to keep workplace health and safety records for a particular period of time. In different types of industries, there might be requirements to keep, manufacturing plants. Universities need to keep student records for quite a long period of time. There are archiving acts that require state government and federal government agencies to keep kind of matters of public record for a certain period of time. So again, I'm sorry, the answer is that there's no one place that you can go to that tells you how long you need to keep information. There's nothing specific to personal information or sensitive information. You need to look at, the type of information and whether there's any specific, sector-specific type regulation. And if there's not, you need to think about the rule that you shouldn't keep it for longer than you reasonably need it. So you can keep it in backup. You can keep it in backups or for archiving purposes, but you need to probably disclose that if that's what you're doing, and have some kind of archiving policy about how long you keep those kind of backups and archives for as well. So it's a huge area, and I think that most organisations will err on keeping information rather than trying to work out what they can and they can't get rid of, which is just meaning that everyone's kind of growing bigger and bigger data sets that are getting more and more problematic. So if I can encourage you to deal with this one head on now, I will.
Okay, so that's all for questions today, Jody. Was there anything you wanted to add before we wrap up?
No, again, I think there are lots of things that I didn't cover. We really tried to just kind of highlight the issues that we thought were of most importance to NFP. So if there is anything else that you would like to cover, please let Tina know and we'll see what we can do. And I hope that today was of some benefit to all the people who joined in.
Fantastic. Thanks so much, Jody, for presenting today, and thank you everyone for joining us. I hope you've all learnt a lot from this presentation and that your questions have been answered. If you do have any other questions that come to mind later on, or any feedback about this webinar, please send that through to events@connectingup.org and we can answer those questions offline. You can also contact Jody directly via the information on your screen. Don't forget that the recording will be available on the website very shortly, and a link will be sent to you, so keep an eye out on your inbox. Again, thank you for being with us. Enjoy the rest of your day, and we look forward to seeing you all next time. Thanks, Jody. Thanks, everyone.
Thanks, Tina. Bye-bye.